Hey, what's up? LegalEagle made this video on the Rittenhouse case, and he's getting executed for it on Twitter for once. So let's get into it.
Rittenhouse acted in the midst of a chaotic protest where many people were legally carrying guns.
I like how he paused there. They were legally carrying guns, as if they shouldn't be legal.
Says that the person. Now, every state has self-defense law that basically says a person who is not the aggressor is justified in using deadly force against an adversary when he or she reasonably believes that they're in imminent danger of death or serious bodily injury. Now,
Good. Devin knows what self-defense is. It's a good start for Devin.
many people thought that when Kyle Rittenhouse admitted on the stand that he intentionally used deadly force on Rosenbaum and Huber, that was a huge tactical blunder. But intentional use.
Who is saying this? He's alleging self-defense. You literally have to admit you shot the dude to allege self-defense. Who could ever think that's a tactical blunder? To be like, yeah, I shot him in self-defense. Got him! It's like, who is LegalEagle talking to? Wow, there's some morons out there. Holy.
Who provokes the attack cannot use or threaten force unless he believes that he has exhausted all other opportunities to escape.
Okay, this basically means the provocation argument never could work. Because even if you provoke the attack, and that person starts killing you, you're like, oh shit, I'm going to die. Even if you provoke the attack, you can still kill them in self-defense. If you believe that you are about to die from the provocation that you did.
Even Rittenhouse's testimony seems to indicate that Rosenbaum didn't lunge at Rittenhouse until he raised his gun at Rosenbaum.
I mean, Rosenbaum was gonna go for the gun regardless of whether or not the gun got pointed at him. I mean, can we be honest about that?
In a 1975 Wisconsin Supreme Court case, the court held that a defendant was a provocateur by virtue of openly bringing a gun into a tavern. The Wisconsin Supreme Court held, quote, the defendant himself testified that after being slapped, he went out to his car, got his shotgun, loaded it, and returned to the tavern. As he was entering the tavern, he was grabbed from the side by someone, and he pushed that person away. He saw Freddie Jones start toward him, and he started shooting. He stopped after 4 shots and after Jones was out of sight. The defendant requests that the court grant him a new trial in the interest of justice. We find no merit to this contention. When the defendant left the tavern, got his shotgun out of the trunk, loaded it, and returned to the tavern, he became the provoker.
What is LegalEagle saying here? In the first case, this guy was struck at a tavern, left the tavern, came back with a gun, and then pointed at the other dude. Right? The conflict was over. This guy goes to his truck, grabs a shotgun, and reinitiates the conflict. How is that the same as what happened here? Kyle's being chased, points the gun at Rosenbaum. I think he turns around, runs away again. And then as Rosenbaum's reaching for the gun, that's when Rittenhouse shoots him, points the gun at him again, obviously, to shoot him. So how can you say that someone leaving a situation, going back to the situation, is the same as an active chase? It's not.
Additionally, there's an 1883 Wisconsin Supreme Court case that says, quote, if one points a loaded gun at another and the other grapples with him to prevent the shooting and is shot, it is murder. And this is
another scenario where I guess this guy's pointing a gun at the other one point blank. And then the guy's like, whoa, don't point that gun at me, and tries to stop him from pointing the gun at him. This is Kyle running away, being chased down, and then someone's putting hands on him. I mean, that is completely different. It's like that Rosenbaum could have done anything else other than chase him down, and Rosenbaum would still be alive today. It's like, it's not even comparable, really.
Now, it's a closer call when you consider Rittenhouse admitted that he pointed his gun at the victims and claimed that when he was pointing his gun, it wasn't a dangerous provocation.
I mean, we know that he pointed the gun at them because he shot them. I mean, we didn't need Kyle to admit that on the stand. That was already known. You tell me that's the provocation? That before I shoot you during the attack, that's the provocation?
A number of people believe that Kyle Rittenhouse provoked the attacks themselves and therefore couldn't use the privilege of self-defense, that by brandishing a firearm or placing himself in the situation, he provoked the attack.
All right, so Wisconsin's an open carry state, and I don't think there's a single open carry state in the country where open carrying, which is allowed by law, is considered an act of provocation. Again, who are these people that LegalEagle is talking to, and how do they get dressed in the morning?
Such a case where the provoked attacker uses deadly force against the provoker, the person engaging in the unlawful conduct is privileged to act in self-defense, but the person is not privileged to resort to the use of force intended or likely to cause death to the person's assailant, unless the person reasonably believes that he or she has exhausted every other reasonable means to escape from or other otherwise avoid death or great bodily harm at the hands of his or her assailant. So,
Once again, Kyle meets this. He easily meets this.
Instruction from Massachusetts. Quote, a person cannot lawfully act in self-defense unless he or she has exhausted all other reasonable alternatives before resorting to force. A person may use physical force in self-defense only if he or she could not get out of the situation in some other way that was available and reasonable at the time. The Commonwealth, that is the state of Massachusetts, may prove the defendant did not act in self-defense by proving beyond a reasonable doubt that the defendant resorted to force without using avenues of escape that were reasonably available and which could not have exposed the defendant to further danger. Again, that's the law of Massachusetts, and it's not the law of Wisconsin.
Right, it's completely irrelevant. Under that ridiculously restrictive self-defense rule, Kyle still would have acted in self-defense because the whole time he was either running or he was on the ground, which is literally the same as having your back up against the wall. He had nowhere to go, and he was surrounded. So he complied with the Massachusetts statute, one of the most restrictive statutes on self-defense probably in the United States. Because even if he aimed the gun, which the DA says he did, and Devin's going to go into this, he still retreated after that. So he would still have self-defense regardless.
Wisconsin does have a duty to retreat where the person provokes the attack against them. Now, at common law,
yeah, there was no evidence, no credible evidence actually, that Kyle provoked anybody in this trial. I mean, the DA raised the argument, they entered in like this doctored photo that looked like he was raising his gun. Actually, it didn't show anything.
Wisconsin law doesn't quite go as far as stand your ground states, which remove any consideration of de-escalating or fleeing before resorting to deadly force.
Yeah, I mean, except he did flee, so it wouldn't have mattered in the end.
But jurors can consider whether someone tried to move away from danger as they assess the reasonableness of a self-defense claim. Juries are
So they shouldn't be considering whether or not he retreated, because it's not part of the law.
Important. The Rittenhouse jury instructions summarize the requirements for self-defense in Wisconsin as the defendant believed that there was an actual or imminent unlawful interference with the defendant's person, and the defendant believed that the amount of force the defendant used or threatened to use was necessary to prevent or terminate the interference, and the defendant's beliefs were reasonable.
Right, and what this is a subjective standard. If you reasonably believed subjectively that you were endangered, a lot of jurisdictions require you to believe that you're endangered reasonably, and also for other people to reasonably believe that you're in danger if they put themselves in your position, which is an objective standard. Alright, this video was too long, so I'm going to rate the first half a 5 out of 10. If I didn't know LegalEagle, I would assume that he knew nothing about criminal law, or he's trying to make the provocation argument work when the facts are not on his side. Let's just say that.